Welcome and good afternoon. I'm glad you've been able to join us here for this forum on same-sex marriage. The nation really has been riveted this week looking at the 2 days of questioning on the same-sex marriages cases in the Supreme Court. And indeed, our own Oye site had received more hits this week than it ever has before in history. And few would have thought 10 years ago, let alone 15 years ago, that the nation would grow so quickly into an acceptance of same-sex marriage. If you look at any kind of polls, the dramatic change has been really something that we all have to take account of, whether that's because of changing culture, mores, changing the impact of social media. We don't know, but the question that some of our panelists will look at today, besides the pure constitutional questions, is what role does that growing acceptance of gay marriage have on the court, or should have on the court. So I'm delighted today to kick off this forum for those and many other reasons, and I'm pleased to introduce to you first Professor Carolyn Shapiro, who is the director of our Institute on the Supreme Court here at the school. Carolyn?
Thank you, Hal. I think the rest of us have decided to talk from here, but thank you all for coming, and thank you. Welcome to those of you who are watching on the internet. I want to thank first Professor Steve Heyman, my colleague. This was his brainchild, and he really did all of the difficult legwork to pull it off. So thank you, Steve. And I'd also like to thank the co-sponsoring organizations of the event. Not only is my institute a co-sponsoring organization, but the Chicago-Kent chapters of the Federalist Society, the American Constitution Society, and the Chicago-Kent Lambdas are all co-sponsoring organizations. So thank you all for your help and support. I'm going to introduce my fellow panelists and then just briefly describe the format. I'm joined up here by three of my colleagues, Chris Schmidt to my left, Professor Schmidt, Kathy Baker to my right, and Steve Heyman at the end. Our format is going to be very simple. I'm going to give a little background about the cases, make sure we all know what the legal issues are that the Supreme Court is considering. And then I'm going to turn it over to my colleagues in the order that I just introduced them, and each of them will speak for about 10 minutes. And then we'll open it up to all of you to ask your questions about the cases. So the background of the first case is Proposition 8. In California, the California Supreme Court held a number of years ago that same-sex marriage had to be recognized under the California Constitution. In response, a group of citizens placed on the ballot in California an initiative which has amended the Constitution. It's known as Proposition 8, and Proposition 8 defined marriage in California as between a man and a woman. It was passed by the voters of California in 2008. Interestingly, the polling suggests that were it to come up for a vote again today, which may well happen depending on what the outcome of these cases are, it would it would fail. So that's another possible outcome in this journey. Proposition 8 was challenged in federal court by a number of same-sex couples who wanted to get married. They said that their equal protection rights were being violated by California. Their federal equal protection rights were being violated by California's refusal to allow them to marry when opposite-sex couples were allowed to marry. And interestingly, there are about 18,000 same-sex couples in California who did get married before Proposition 8 was passed, and after California's Supreme Court said that same-sex marriages had to be recognized, and those marriages are still valid in California. So another claim is that treating those same-sex couples differently from people who want to get married post-Proposition 8 in California is unconstitutional. The district court in California said, held a trial and concluded that, in fact, it violated the Equal Protection Clause to prevent these individuals from marrying. The Ninth Circuit then reviewed the case and held on a much narrower ground that the Proposition 8 was unconstitutional, and the ground was that it was not okay for California to recognize the marriages of 18,000 same-sex couples, but then to turn around and say, we're not going to recognize the marriages of any other new same-sex couples, and that violated the Equal Protection Clause. That's the merits that are before the court today. The court could decide, or yesterday, technically, the court could decide to say that Proposition 8 is unconstitutional and that as a result, same-sex marriage must be recognized by all states in the United States. The court could decide to take a much narrower view, something like what the Ninth Circuit said, and say, well, we don't know about the whole country, but in California or in California and states that allow civil unions, we're going to say that they must recognize same-sex marriages. Or the court could not reach the merits at all. And the reason the court might decline to reach the merits at all is because the state of California, which would ordinarily be defending its own law, has declined to do so. The governor and the attorney general of California have said, we don't want to defend this law. We think it's wrong. We think it's unconstitutional. So the people who are trying to defend the law in the Supreme Court are a group of the original proponents of Proposition 8, and they say, we should be able to defend the law, and in fact, the California Supreme Court says under state law, they're allowed to defend the law, but it's not clear that that's enough to create what's known as an Article 3 case or controversy, the kind of live controversy that's necessary in order to have a case in federal court. So that issue got a lot of attention yesterday in the oral arguments. I will say just a couple of other words about that oral arguments yesterday. It seemed quite plausible that the Supreme Court would, in fact, decline to reach the merits. It also seemed somewhat unlikely that there were 5 votes to say that same-sex marriage must be recognized nationwide. So it also seemed, I think, somewhat unlikely that there were 5 votes to say that same-sex marriage absolutely is not a constitutional right and need not be recognized at all. So there's a lot of room for the court to do a lot of different things. There's short of going all the way in one direction or the other. The second case is United States versus Windsor, and this case has to do with the Defense of Marriage Act. The Defense of Marriage Act was passed in the 1990s after it appeared that perhaps Hawaii was going to recognize same-sex marriage, which they in the end did not do. And the Defense of Marriage Act says 2 things. One is that one state does not have to recognize marriages between people of the same sex performed in other states. That's Section 2. That's not under review today. It also says under Section 3 that for purposes of federal law, anytime the word marriage or spouse or husband or wife is used in federal law, it only refers to opposite-sex couples. And that is Section 3 of DOMA, and that is what is being challenged in the federal courts at this time. Can the federal government say it is unwilling to recognize valid same-sex marriages performed in states that have chosen to recognize those marriages? There seemed to be a fair amount of skepticism today at oral argument about whether or not the federal government can do that. Some people seem to think that the federal government can't do that because of equal protection concerns. But some people, and notably Justice Kennedy, seem to think that perhaps the federal government can't do that because it's really a state job to define marriage, and the federal government shouldn't be doing that at all. Again, however, the court might not reach the merits. They might decide that they don't have jurisdiction for similar reasons. The United States government under the Obama administration has also declined to defend DOMA, although they are saying we will continue to execute DOMA, which means that we will not provide the benefits to same-sex spouses that federal law would otherwise provide them. We will continue to withhold those benefits, but we will not in court defend the law. So there's a question about, given that the United States essentially asked the lower court to say that DOMA is unconstitutional, which the lower court then did, can the United States then come to the Supreme Court and say, we want you to review that judgment that we asked for? That's the simplest version of that argument. Because of that, some of the members of Congress who supported DOMA, 2 in particular, the Republican members of the Bipartisan Legal Advisory Group, have also stepped in and said, we want to defend DOMA. And so there's another question about whether they have standing to do that, similar in some ways to the question about the Proposition 8 proponents. So again, there are a variety of different possible outcomes, including a sort of anticlimactic outcome in which this court doesn't reach the merits in either case. Based on the reports that we've heard from the oral arguments, it seems somewhat more likely that they will reach the merits in the DOMA case, but it's, as you all may remember from last year's Affordable Care Act oral argument and the aftermath, it is very dangerous to make strong predictions on the basis of what happens at oral argument. So that's the background, that's the setup, and I'm now going to turn it over to Professor Schmidt.
All right, so the topic I'm going to look at today is the use of historical analogies in the litigation over gay marriage. The debate over same-sex marriage has been overflowing with references to the supposed lessons of history. So I'm going to step back and look at a few of the more prominent ones that we've seen jumping around both oral arguments as well as the news accounts and commentary on the cases over the last few days. The two groups of historical analogies that I want to look at, one centers around the civil rights struggle, specifically with references to Plessy versus Ferguson, Brown versus Board of Education, and Loving versus Virginia. And the second group centers around abortion, specifically with references to the lessons of Roe versus Wade. So I want to consider briefly how these historical analogies function. That is, the kind of work they do when we assess what the court might do with these cases, and also when we try and decide what we think the court should do with these cases. So both can be used as tools for prognostication as well as for developing our own commitments on these particular issues. Now, the key issues that historical analogies seek to illuminate, at least in the same-sex marriage context, does not seem to be all that much to do with formal law. Most of the time, when you see people referencing things like Brown, Loving, or Roe versus Wade, they're not talking about law per se. They're talking about the larger institutional concerns that the court faces, questions of timing, of institutional competence, and the likely consequences of particular court rulings. So let's look at some of these the issues. We'll start with the civil rights analogies. The civil rights analogy has been used to offer a rather clear, even stark message, because the civil rights, the lessons of the civil rights cases like Brown and Loving, do seem to be pretty clear, at least on the surface. The point of dispute with these cases tends to be not so much on what the lessons of history are, but more about whether this particular issue, same-sex marriage, adequately fits these historical analogies. The analogies, Plessy is clearly get thrown around somewhat, although it doesn't get that much mileage in these debates because the debate about Plessy is not really much of a debate at all. Anytime someone says this looks like Plessy, you immediately say, well, we don't want to do that, right? Plessy is clearly wrong. So that's mostly a rhetorical critique, although there is some analytical bite there if you try and sort of get into justices' heads to try and, the advocates certainly are trying to say this, could look like a Plessy, if not today, than a generation from now. Brown seems to have more traction. We saw the Brown case referenced repeatedly in the oral arguments yesterday. So this has to do with the 1904 decision in which the court struck down legally mandated racial segregation in the schools. Again, like Plessy, the lesson of this, sort of from a general level, is pretty clear. Brown's clearly right. It's the reverse of Plessy. Now, Brown was deeply contentious for a time. It might have sparked some white segregationist backlash in the South, but this is a ruling that was clearly ratified by the flow of history, and every justice on the court, including Justice Kennedy, would probably love the opportunity to have a Chief Justice Earl Warren kind of moment to right the great Brown decision of our time. But then we need to look at it and say, well, is this accurately described as another Brown? And I think the answer to this is perhaps. We also need to think about this idea of analogical fit. If you make an analogy to the past, does it really make sense? So a few facts about Brown, just to give us some tools to think about this analogy. Public opinion is always useful to look at with these analogies, and public opinion on school desegregation around the time of Brown was actually about 50% nationally, not too far off where public opinion is today on gay marriage. One difference is public opinion was much more regionally differentiated on school segregation. Clearly the white South was strongly opposed. The North was more in support. You have regional breakdowns in the same-sex marriage issue, but they're not quite as pronounced. Both issues have powerful regional components, as I said. In both cases, you actually have the executive branch doing the same work, which is the executive branch in the school segregation cases, and Brown came out and against school segregation in support of the Brown decision. They argued the case as amicus. And we see a similar dynamic with the Obama administration coming out in support of same-sex marriage. And in both cases, Congress is pretty much on the sidelines. Congress is not very much involved in this debate, nor was Congress very much involved in the school segregation issue back in the 1950s. So there is some fit there. I will say that the key hang-up, the key difference, if you want to differentiate these cases, if you want to say, well, Brown doesn't quite fully fit as an analogy, is with looking outside the courts to what the political process is doing. Gay marriage is doing quite well in the political process. There's lots of hiccups along the way, but the general trend has been increased recognition on the state level over the last generation or so. School desegregation, not so much back in the 40s and 50s. You have northern schools, which had some segregation, some de facto, some by law, that were loosening these restrictions, but the southern states really weren't moving very quickly at all, if at all, on these issues. So when the court was looking at this issue, they could see this as an issue in which there is national support, at least 50% national support, roughly speaking, higher for the more elite segments of society, higher for the more educated segments of society, which the court does tend to be more responsive toward. But they could also say that this is an issue that's important, that the country seems to be moving on, but it's an issue in which the political process is not doing its job, it's not being responsive, largely because of the strong white segregationist resistance and the lack of voting power the blacks had because of disfranchisement in the South. So I think that's an important qualification we want to put up with that particular analogy. The second analogy, and the one that came up even more than Brown, I believe, in the oral arguments yesterday, and that's to Loving versus Virginia, which is the 1967 decision where the court struck down prohibitions on interracial marriage. Again, one of these decisions that we can all agree clearly right, judged by any proper measure of when the court gets it right. Here the fit's perhaps better. We actually have a marriage issue going on here. It's clear at the time of Loving that disapproval for interracial marriage or at least approval for legal prohibitions on marriage, which is slightly different, meaning that someone could say, I don't really like interracial marriages, but we shouldn't have laws saying you can't do it. That kind of position was logical. All that was trending in a more liberal direction, meaning support for these laws was going away. So the trend is analogous to the gay marriage issue. But the reasons here, too, while the lessons of the past are more complicated, if you want to use Loving as an argument for why you should, the court should rule in favor of a constitutional right to gay marriage, Loving also is something of a cautionary tale. Loving is also a tale about waiting until public opinion is well developed, because the court, right after Brown versus Board of Education, actually had an opportunity to face the interracial marriage prohibitions in the late 1950s and chose not to. For no good legal reason. The reason they chose not to is because this was just too much of a hot-button issue. So they were going to hold off. And they actually held off for 13 years after Brown. The logic of Brown would seem to mean that interracial marriage prohibitions are unconstitutional. They held off for a time. By the time they got to in 1967, support for getting rid of these prohibitions on interracial marriage was much stronger. And actually, it was surprisingly uncontroversial when it actually came down. So if you want to use a Loving analogy, one of the arguments is that the court should actually wait a while, wait a generation to make sure this is developing. But then, of course, the question comes, well, where are we? If we want to make the analogy to the civil rights movement, are we in 1954 when Brown came down? Are we in 1967 when Loving came down? And that's a debate you can have about history and as well as the present. I mean, my 2 cents, I think, we're probably somewhere in between. I don't think the support for gay marriage is where the support for getting rid of prohibitions of interracial marriage was in 1967, but it seems like we're further along than Brown in that the decision, if it did come down, would not be as controversial as Brown. The last historical analogy I want to touch on, and that's another one which does not come up in oral arguments, but is very much circulating around these decisions, and that has to do with abortion and Roe versus Wade. The analogy of Roe versus Wade is actually a bit of a harder one, because the lesson of Roe versus Wade is actually less clear. So you need to sort of figure out, well, what is the lesson you can take away from it? Was Roe right? Was Roe wrong? That's actually deeply contested. Even if you agree with the right to abortion, there's still an issue there. And then you also need to do the same move about, well, does the present circumstance actually fit? Is the analogical fit decent enough? Just briefly, the standard account of Roe versus Wade focuses around the idea of backlash. So the standard account is that there was a liberalization toward more support for a women's right to an abortion leading up to Roe versus Wade. The Supreme Court issued this decision in which they struck down laws in some 46 states. There's a very strong definition of a woman's right to abortion, and that in turn sparked a backlash, meaning what we call the pro-life movement was formed because of that, and in the end, it actually might have set the pro-choice movement back because it sparked this strong backlash. Now, whether that's an accurate portrayal of what actually happened is actually one of the things that is debated. Some people say no, the idea that this is always contentious, there's always backlash. The court was just one player in this sort of roiling debate. But other people actually do believe that the court might have gotten too far ahead of itself. Most importantly for our circumstances here is Justice Ginsburg has been quite open. She's clearly a supporter of Roe versus Wade in terms of the principle. But she wonders maybe this was an example of the court moving too far too fast, and then some people are trying to read the tea leaves saying, does that mean that Justice Ginsburg might have the same feelings when it comes to the gay marriage issue here? Comparing gay marriage to abortion, the big difference you want to look at, if you're looking at public opinion numbers, which is the most obvious factor you'd want to look at in terms of the kind of consequences of a decision, is that public opinion on abortion around the time of Roe was about evenly divided in society. The numbers are complicated, but roughly evenly divided. Public opinion today is about the same. All right? So if we say that public opinion on same-sex marriage is about evenly divided today, what we can say is differentiates the same-sex marriage issue is the trend. The trend is so much clearer, and it's really hard to imagine any kind of event, even a very controversial Supreme Court decision, that would actually put a roadblock in that trend. So even if you buy the backlash narrative against Roe versus Wade and saying that Roe actually did set back the right to abortion by going too far too fast, it's hard to see how that would actually fit this particular decision with the trends towards support for same-sex marriage going so powerfully. So in the end, these historical analogies, we're going to see a lot of them. They're going to continue to come out as people try and predict what's going on. But the history never provides an easy answer, but it does provide some useful perspective to try and get a sense of what is likely to happen as well as what we think should happen. Thank you.
Thank you, Chris. So I'm now going to ask my colleague Kathy Baker to talk a little bit about, I think in particular, the DOMA case.
Yeah, I'm gonna talk almost exclusively about DOMA, but I never actually do what I say, so we'll probably end up veering into something else as well. And to make things a little weirder, I'm not even going to start off talking about the DOMA case that was before the court. So the DOMA case that was before the court and argued today involved a woman whose partner died, and she had to pay taxes on what was left to her by her partner as if she was a non-spouse because the federal government, for income tax purposes, refused to recognize the same-sex marriage that the state of New York had recognized. To give you a taste, I'm going to give you a bunch of these tastes of the sort of level of complexity. Edie Windsor actually had not gotten married in New York. When Edie Windsor's partner died, New York wasn't granting same-sex marriage licenses. What New York was doing at that point was recognizing same-sex marriages that had been entered into someplace else that did recognize same-sex marriage. So Edie Windsor and her partner got married in Ontario and then settled back in New York, and New York at that point was recognizing them as married because they had gotten married in a place that did recognize marriages, but they couldn't have gotten married in New York at that time. The case I actually want to tell you a little bit more about, though, is the case that the court did not accept cert on, because it actually, I think, does a nicer job, the history of that case does a nicer job of presenting the conflict or the tension between the 5 votes that may, in fact, strike down DOMA. So the 5 votes that may strike down DOMA, if they do, are Justice Kennedy and the 4 more traditionally liberal justices. And Justice Kennedy, I'm incredibly bad and unexperienced at this, but if one listens to the oral argument and, as Carolyn says, does what one shouldn't do, which is try and guess from it, you think that Justice Kennedy wants to decide something more on something like federalism grounds, and the more liberal justices want to decide something more on discrimination, sort of suspect classness kind of grounds. And together, we might actually strike down DOMA. So the case I want to tell you about is actually the case that was brought in Massachusetts. It was brought in the District of Massachusetts, and it was brought jointly by GLAAD, Gay and Lesbian Advocates and Defenders, and the state of Massachusetts. And they brought it together challenging DOMA, and GLAAD was making an equal protection argument, and the state of Massachusetts was making a federalism argument. The state of Massachusetts said, you are hurting our rights as a state in not recognizing these marriages, because previously, as a state, we have had the right to confer this status on people. And once we conferred that status on people, that was really, really important to them. And there were all sorts of consequences that followed from that. And by not recognizing these marriages at a federal level, you are taking away the power we had as a state to grant that status. That argument actually won in the District Court of Massachusetts. And the District Court said that DOMA both violates the 10th Amendment and violates the 14th Amendment. In that litigation, it was the state of Massachusetts and GLAAD versus the Department of Justice, which at that point was defending DOMA. Subsequently, DOJ dropped out, right, because the Obama administration changed its position. BLAG, the Bipartisan Legal Advisory Group, stepped in to appeal. On appeal, the Justice Department didn't contest the equal protection finding, but did contest the federalism finding. So the Justice Department argued, well, you should sort of overturn the district court to the extent they said there's a federalism problem, but you shouldn't overturn the district court to the extent they said there's an equal protection problem, right? Which just shows actually how incredibly messy all of these standing issues sort of become, because the DOJ has kind of been involved in some of these cases from the beginning, to the extent that the argument is that DOMA's problem is that it is some sort of violation of the 10th Amendment. What the First Circuit decided in Gill was actually some sort of recipe that involved a little bit of federalism concern here and a little bit of equality concern there. And you mix it all together and you get a kind of scrutiny that was ill-defined, but clearly something greater than what has traditionally been known as rational basis, right? So the First Circuit said, we're not quite calling gays and lesbians a suspect class, but we've got these other cases. We've got Romer and we've got Lawrence, and it's clear that we need to have some sort of concern for the fact that there might be a statute that is infringing on these rights that seem to be pretty important because they have to do with family and privacy and these other things that the Supreme Court has traditionally said is important. And by the same token, though we're not going to say this is actually a violation of the 10th Amendment, we've got these weird federalism concerns here because Congress has done something with DOMA that it's never, ever done before. It's never come in and tried under some sort of uniformity mantra to define marriage for federal purposes. Congress has always left that up to the states before. So regardless of whether Congress has the power to do it, it's never done it before. And because it's never done it before, it kind of looks fishy to us. So we're going to apply some level of scrutiny that is great enough to strike down DOMA, because you put all those things together and it smells bad. That's basically what the First Circuit said. And you're laughing, and the Second Circuit mocked the First Circuit quite explicitly when the Second Circuit in Windsor applied much more traditional heightened scrutiny to gays and lesbians as a class to strike down DOMA. But I'm actually going to suggest that, that there's a lot to be said for the First Circuit's reasoning, okay? And here's why I'll say that and defend it. There are problems with both the equality approach and the federalism approach. And there are problems that actually may manifest themselves for the gay and lesbian community. So let me talk first about the problems that might come with the federalism approach. So guessing, pure conjecture, I know nothing, that Justice Kennedy writes an opinion that says the problem with DOMA is that it implicates all of these federalism concerns and it takes powers away from states in ways that are impermissible. The problem with thinking about all of this in federalism terms, for instance, is if Congress doesn't have the power to do this, to define marriage the way it did in DOMA, what happens if 6 to 7 years from now, there's actually a pretty big groundswell for some sort of federal definition of parenthood because there's still some states that won't recognize second parent adoptions. There's still some states that aren't treating children born into a gay marriage as children of the non-biological spouse. And Congress wants some sort of uniform rule with regard to parenthood, that if you're traveling into Alabama, say, and get into a car accident, that Alabama has to recognize you as a parent if Illinois did, because we want federal uniformity with regard to parental status recognition. Well, if Congress can't define marriage at a federal level, it's not clear they can define parenthood at a federal level, and so that might be a problem, right? The desire to create uniformity in a manner that might protect gay and lesbian parental rights would actually be undermined by a ruling that said that Congress can't create uniformity with regard to marriage as it did in DOMA. Here's the problem with the equal protection argument. Or with, I should be more clear. Here's the potential problem with thinking about gays and lesbians as a suspect class. I actually have thought long and hard about how it could come back to bite the gay and lesbian community specifically to treat them as a suspect class, and I can't come up with a problem. But I can say this: for every other group that has been treated as a suspect class, it has come back to bite them in some ways. Okay, so I think that pretty much everybody who thinks long and hard about problems of institutional racism in this country now thinks that strict scrutiny, for the most part, disserves the interests of African Americans. It is used primarily now in the courts to strike down affirmative action programs. People who want to think about creatively about ways of dealing with racism run into tremendous roadblocks because of how strict scrutiny requires any sort of delicate, nuanced approach to race to be thrown out. With regard to gender, where the level isn't quite strict, it's something called intermediate. The main problem is just nobody knows what that means, right? And so to put this into a little bit of relief, as Chris mentioned, everyone sort of knows with regard to race, right, that separate's not equal. And in fact, people have used that as a reason for why civil unions couldn't be constitutional, actually, because if you have a regime that recognizes civil unions even as it recognizes marriage, that creates a separate but equal regime, and that can't be right because everyone read Brown and everyone knows that's not right, right? Except with regard to gender, we actually allow separate but equal. I mean, for the most part, if you look hard at the ways in which we allow gender to replicate itself through state actors, whether it's different bathrooms in state institutions, whether it is at times different gendered schools for high school. Title IX, which as a college athlete is a statute that is near and dear to my heart, is one huge codification of a separate but equal regime, okay? And so if we're gonna treat gays and lesbians as some sort of suspect class like gender, does that mean you can have intermediate scrutiny that allows for something like a separate but equal regime like that? That's disquieting to some. I'm going to say two other things about a potential problem. As I said, I couldn't come up with a reason why sort of treating gays and lesbians per se as a suspect class could be problematic. But once you throw in the other two letters of the acronym, once you throw the B and the T of the LGBT in there, it gets very messy very quickly, right? Because once you start talking about B, then you have real problems with immutability. You have real problems with figuring out why it is that bisexuals should be considered part of this class. Bisexuals have been able to get married, for instance, forever. Is it really that they get to choose who they want? I mean, that the bisexual doesn't get his optimal spouse? Well, you know, a lot of people would say optimality? I'm not sure. Right, so what's, you know, where do bisexuals fit into that? When you start talking about transsexuals and transsexual rights, there's this profound tension between the essentialism implicit in transsexual rights. I have a right to be a different gender, right? And gender discrimination doctrine generally, which for the most part completely is rooted in the idea that any denomination of gender, and certainly any sort of essentialist gender, is violative of basic equality principles. I'm way out of time.
Thank you. Steve Heyman.
Thanks. So I want to talk about the two cases that the Supreme Court just heard from the perspective of ideological and cultural conflict. So our country, as everybody knows, is marked by deep social and cultural and political, religious divisions. This fact is highlighted every time we have a presidential election, every time we talk about red states versus blue states. And it also becomes clear every time we talk about hot-button issues like abortion or affirmative action. And of course, the same thing is true of the debate over same-sex marriage. Those who oppose it argue that there's an inherent connection between marriage and procreation. They're concerned that this connection would be dissolved if same-sex couples were allowed to marry. And that this would undermine the traditional institution of marriage. So on this view, Prop 8 and DOMA are not excluding anyone, as Chief Justice Roberts said yesterday. They're not excluding anyone. It's just that the purposes for which we have marriage simply do not apply to same-sex couples. By contrast, the supporters of marriage equality understand marriage in a very different way. They see it as a relationship between two persons that's based on mutual love and commitment. If you look at it from that point of view, then there's clearly no principled reason to limit marriage to opposite-sex couples. Because gay and lesbian couples are clearly just as capable of forming loving and committed relationships, and indeed of having or adopting children and raising them together. The supporters of same-sex marriage also see marriage as a core civil rights issue, and they see Prop 8 and DOMA as a fundamental denial of the dignity and equality of LGBT people. In a debate like this, this kind of a cultural conflict, there's bound to be a good deal of acrimony and misunderstanding. The supporters of Prop 8 and DOMA sometimes accuse their opponents of having an agenda, right, the homosexual agenda, to destroy the traditional institution of marriage. I saw this great sign from one of the rallies yesterday at the Supreme Court that said, "My homosexual agenda," which is being held by a woman. And it said, 7 a.m., wake up, 7:30, feed the kids, 8 o'clock, get them off to school, and 5 o'clock, come home and make dinner, 7 o'clock, go out and break up a heterosexual marriage. 9 o'clock, put the kids to bed. The supporters of marriage equality, on the other hand, sometimes accuse the other side of being nothing but bigots, right, motivated by homophobic animosity towards gay people. It seems to me, though, that at root, the conflict here really stems from a clash between two very different worldviews. These are views that reflect the social and cultural experience of the people that hold them, and they're so deeply ingrained in people that in a lot of ways they help to form the identity of the people who hold them. And this, of course, is what makes these sort of issues so intractable. So what do we do in a situation like this, where we're sort of at loggerheads with one another over an issue like this? And in a situation like this, it's kind of natural to turn to the Supreme Court to come in and resolve the issue. And in fact, yesterday, just about the only point on which Charles Cooper, for the supporters of Prop 8, and Ted Olson, who was challenging it, just about the only point on which they agreed was that they really wanted the Supreme Court to decide the case. The problem, though, is that the members of the court don't stand above the society, right, however much they might like to think that they do. They reflect the society. And as the arguments yesterday and today made clear, they're just as divided about same-sex marriage as the rest of us are. So most of the conservative justices voiced support for the traditional idea of marriage. Most of the liberals were sympathetic to same-sex marriage. Then the question arises, what should the justices do in a situation like this? And one possibility is for them to simply slug it out, right, within the court. And I mean that metaphorically, but it would be, it is kind of a funny idea to think of Justice Scalia and maybe Justice Kagan sort of deciding this issue by single combat. So you could have a situation where simply, each justice votes his or her own sort of worldview, and then you count up the votes, and whoever has 5 votes wins. There are some cases in which the justices may need to do this, but there are also at least a couple considerations that may counsel restraint. One is the sense that, and Professor Schmidt kind of alluded to this, the sense that when you're dealing with such a fundamental issue like this, that you might want to take your time about it, that the court might not want to try to resolve the issue too quickly, but should let it play out for a while at least within the society as a whole. And then the second consideration is a desire to find some kind of common ground, right, as elusive as that might be, so that the court and the Constitution don't appear to be taking sides in a culture war. When you listen to yesterday's argument on Prop 8, then it becomes clear that some of the justices are in fact quite sensitive to these concerns. There are some of them, like Antonin Scalia and Samuel Alito, who did seem to be pressing for the court to make a sweeping ruling on this case. And that would be, in their case, a ruling that would uphold Prop 8 and would say there's simply no constitutional right to same-sex marriage. But most of the other justices, and Justice Ginsburg was mentioned, seem wary of issuing such a broad ruling on either side of the case, at least at this time. And that was also certainly true of Justice Kennedy, who openly wondered about whether the court made a mistake in taking this case at all. So while this is the point where I have to make this kind of standard disclaimer that it's very hazardous to make predictions about this, and I think it's very well founded, I do think that one thing that's pretty clear from the arguments yesterday is that the court is likely to resolve the California case on narrow grounds rather than broad, sweeping grounds. And in fact, as Professor Shapiro mentioned, it's quite possible that the court won't even reach the merits of the case at all, but will take one of 2 escape routes. So escape route number 1 is to hold that the sponsors of Prop 8 had no standing to appeal the district court decision that struck it down. The other is to do what Justice Kennedy suggested a couple times at the argument and dismiss the writ of certiorari as improvidently granted. And that's sort of a fancy way of saying, oops. We never should have taken this case in the first place, and we want it to go away. If the court does either of those 2 things, then what would be the practical result of that? And that's also not clear, but probably it would leave some of the lower court decisions in place, right? Meaning that, that Prop 8 would be invalid, because a lower court had in fact enjoined it, and that gay and lesbian couples in California would have a right to get married, but the decision would be limited to that state, and in the rest of the country, the debate would continue. In the DOMA case that was argued today, the situation may be different. In this case, the court isn't being asked to change the traditional definition of marriage. Instead, Edie Windsor and Thea Spire were married as a matter of state law, as Professor Baker explained. And so the question is simply whether it's constitutional for the federal government to refuse to recognize that marriage. In that situation, it's possible that a majority of the justices will feel comfortable in striking down the law, very much on the grounds that people have talked about, the idea that in our constitutional system, marriage has traditionally been defined by the states. The federal government has almost always recognized marriages that are valid under state law, except in rare situations like the movie Greenhouse, right, where you're getting married in order to commit immigration fraud. So in a situation like this, the question is whether the government, federal government has a good reason for refusing to recognize same-sex marriages that are valid under state law, and it's not clear that there is any good reason. And that would be especially true if the justices were persuaded to hold that sexual orientation is a quasi-suspect class that triggers heightened scrutiny. And in fact, throughout the litigation, the defenders of DOMA have pretty much conceded that it would not survive any kind of heightened scrutiny, so that they're strongly arguing only for rational basis scrutiny. Again, it's always perilous to read the tea leaves. The early reports from today's argument suggest that it's possible that Justice Kennedy would join the 4 liberals on the court to strike down this section of DOMA. As a supporter of marriage equality myself, I wish the court could go further and protect the right of everyone to marry the person that they love now. If the court instead does something like what I've been talking about, I think that would still be a pretty good outcome. A decision to strike down DOMA would be a huge blow for gay rights, and it would give a strong impetus to the movement for marriage equality. In recent years, as Professor Schmidt said, the movement has already gained a lot of momentum to the point where it has support not only from liberals, but also from a growing number of moderates and conservatives. When you combine this with the demographic reality that marriage equality has overwhelming support among younger people, it's starting to seem like the handwriting is on the wall. So even if the court does decide to let the process play out for some time in the social and political arena, the trend is likely to favor same-sex marriage. And then once there's something like a national consensus on the issue, the court might well decide to revisit the issue and hold that same-sex couples do have a constitutional right to marry. Thanks.
Thank you, all three of you. We'd like to give you all an opportunity to ask your questions. There are 2 microphones up here at the front, which we would like you to use because so everybody can hear your question, including the people who are watching on the internet. So we will start taking volunteers now. There will be no cold calling at this time. I have questions, but surely some of you must have questions. Come on up.
Feel free to form a line at the microphone if you have other questions.
So this is for anyone really. Are these actually on?
They should be, but lean in a little more.
Okay. Anything?
No? All right, I'll repeat the question.
Talk loud.
Okay. So this is for anyone really, but how big of a blow is it to the gay rights side if the court decides that rational basis is the standard that will apply here? How necessary is it that the court moves beyond the rational basis standard to reach the sort of gay merits, the gay rights merits?
I'll start with that. Right, so great question. I think it all depends on how the court used the rational basis review, right? So if they were to use it to strike down DOMA and or Prop 8 and say that even under rational basis that they didn't pass, then that would actually be following in the line of 2 decisions that they've made in the past. In Romer against Evans, in the mid-1990s, Justice Kennedy wrote an opinion saying that Colorado's Amendment 2, which basically repealed all civil rights protections for gay and lesbian people and forbade municipalities or the state legislature to pass any new anti-discrimination laws in their favor. Justice Kennedy said there's no rational basis for this. This is motivated simply by animus against gay people. And then again in Lawrence against Texas in 2003, again, Justice Kennedy, writing for the court, struck down the anti-sodomy laws. And in that case, again, he said there's not even a rational basis for this law. When you read the arguments for the past couple days, there's, at least leaves open the possibility that that a majority might do the same thing here. And if they were to do that, it would, I think, not be in any way a setback for the gay and lesbian community. On the other hand, if they were to invoke the rational basis standard as a basis to uphold either of these laws and to repudiate the idea the gays and lesbians, trigger any kind of heightened scrutiny for discrimination, then I personally think that it would be a huge setback. Professor Baker explained that there's a lot of complexity to this issue, and nothing in this whole equal protection area is in any way simple. But for them to simply say, as maybe Scalia and Alito sound as though they'd like to say, that this just is not a constitutional problem, so that if you can even conceive of any reason why the state might have wanted to pass a discriminatory law, that would be enough to uphold it, I think that really would start to look like Plessy.
I'd just add a comment from yesterday's oral argument. The defender of Prop 8, Charles Cooper, had to struggle with even articulating a rational basis for for Prop 8. And he was asked by Justice Sotomayor whether there could be a rational basis for discrimination against people on the basis of sexual orientation in any context other than marriage. And he couldn't come up with one. He was also asked to identify what the rational basis was. What is the concern here about recognizing same-sex marriage? And what he said was, first, well, there could be harms to the traditional definition of marriage, sort of along the lines of what Professor Heyman said. But when he was pressed on that, what he said was, look, nobody can see what the future looks like. Changing this bedrock institution of our civilization will have consequences. We don't really know what those consequences are, and therefore it would be reasonable, read rational, for the average voter in California in 2008 to not be ready to grant same-sex marriage rights. That's not a really very strong argument even under rational basis. Sanford.
I want to throw this first to Professor Baker, because your comments got me thinking along these lines. What if the court in the DOMA case were to split 5-4 two ways, with Justice Kennedy and the 4 liberals voting together, but on different rationales? DOMA would be struck down, but the precedential effect would be?
I'm not the expert in this, but I think that's what's going to happen. And the precedential effect will be minimal. I mean, for those of everybody who hasn't had and/or has forgotten, if 5 justices vote that any classification on the basis of sexual orientation triggers strict scrutiny for DOMA, then DOMA disappears, and tomorrow I walk into a Justice of the Peace's office anywhere in the country that doesn't allow gay marriage and try and marry my partner, and the Justice of the Peace says, no, we don't do that, and I then sue and challenge that law, and that law gets reviewed under strict scrutiny, and though it will take some years, right, and that may be all Justice Kennedy thinks we need, right? It will take some years, and Justice Kennedy says, and in a few years we'll be there, and popular opinion will have changed enough and it will be okay. But failing that, right, if we only have 4 votes for strict scrutiny, then I think that DOMA gets struck down and that's it. And I think that the people that originally brought the DOMA challenges understood all of this. I think that they did not believe popular opinion would change as rapidly as it has. I don't think anyone really predicted that. I mean, maybe some people did. Very, very smart people did. But most people didn't. And they didn't want to put Justice Kennedy in the position of having to find gays and lesbians as a suspect class, having to trigger strict scrutiny in order to strike down DOMA. I think they knew what they were doing.
More questions?
Yeah.
I guess, first of all, I want to say that I do think that DOMA should go out the window. What I'm particularly concerned with as pertains to the U.S. v. Windsor case, when we're talking about the standing issues as far as BLAG litigating this case. Now, I'm concerned moving into the future, if we say that BLAG doesn't have standing here and the government doesn't defend a law in the future, where does that leave us as far as, you know, Congress passed a law, says we want this enforced universally, and the executive branch says, okay, we're just not going to enforce the law. So where do we go from here if we say that BLAG doesn't have standing to defend the law?
I'll take a crack at that one. So I think this is actually a very complicated and important question. What happened, which implicates questions about what is the executive supposed to do when it thinks that a law is unconstitutional. And you know, for the most part, the executive enforces, executes, and defends laws, even when the executive doesn't like those laws as a matter of policy, because that's what Article 2 says it's supposed to do, right? Take care that the law is faithfully executed. And as long as it can make a good faith argument that something is constitutional, it almost always does, even if it doesn't like the underlying law. But once in a while, it happens that there's a law that the executive just doesn't believe is constitutional. So what should it do? And in this case, the Obama administration has, in a sense, tried to split the baby. And in a sense, right, Chief Justice Roberts suggested that the Obama administration was kind of wimping out, didn't have the courage of its convictions. But what they've said is, we won't defend it. We're not going to walk into court and say it's constitutional. But under Article 2, we're supposed to execute the law. So we're not going to pay out money to people via benefits that they think, you know, that they would be entitled to if they were in heterosexual marriages, in order to, that would violate our Article 2 obligations. So we have to continue to do that. Nonetheless, we won't defend the law in court. I think that, in my view, should be enough to create a case or controversy, because there is a dispute over whether or not the government is going to pay Edie Windsor this money that she has paid in taxes, whether she's going to get a refund. And so the question then is, well, what if the government were to take a step further, right? What if the Obama administration said, no, we will pay out this money, right? And who would then have standing to sue over it? Right, because there would be no dispute between the government and Edie Windsor about whether or not she was going to get her $300,000. And I think you're exactly right. That not giving BLAG standing would give rise to the possibility, for example, of collusive lawsuits. I think the same thing is true personally in the Prop 8 case with respect to the proponents. Having said that, the Supreme Court has held previously in a case called Raines versus Byrd that members of Congress don't generally have standing to come in and say this law has affected my powers as a member of Congress. So how that case would actually make it very difficult for them to recognize standing on the part of BLAG. But you've identified a real concern. Daniel?
Hi, I think I want to express a concern, an institutional concern that perhaps you can allay for me. As Professor Schmidt so easily demonstrated, the court is put constantly in a political position. You know, we like to think of the court as not kind of a political branch, but obviously it is. And I think it was Professor Baker that said that, maybe I'm wrong, but that the court is a reflection of society, or maybe it was Professor Heyman. But I don't know if that's actually true. And if it is, I think maybe it's a very inaccurate reflection of society. So when I think of the potential pro-democracy or the democracy reinforcement ideas that you could apply to the court, either term limits or maybe elections or something to bring the court more in harmony with the kind of democratic ideals that we as a society want to be governed by, it just seems that the court is ill-equipped structurally to address this problem in a way that would be satisfactory for the community. But at the same time, to say that means that potentially lots of people that are being discriminated against right now would be without recourse, and they would just have to wait for the moment to happen or the moment to arise that they would have their rights respected. So that's just the concern that I have. It's not really a question, but perhaps you can show me how I'm wrong.
Yeah, I think you've identified exactly the way it works, right? I mean, this is one of the ironies of constitutional protections for minority rights, is that historically the Supreme Court tends to only protect minorities when they become popular enough to have general consensus that the minority rights are worth protecting. So it doesn't mean that the minority needs to become a majority, but the minority needs to get enough supporters and allies within a majority to become an effective political majority. But then the irony there is, well, if you actually have the majority support in the society, then why don't you just go to your legislatures, which is the majoritarian institution, right? It becomes a little bit circular. Now, you do have situations in which the democratic process breaks down, and then that's a pretty good justification for the court stepping in. And that's why I talked about Brown versus Board of Education as having a very strong justification that this is something in which you actually do have a sea change in where the nation is on this particular issue, but it's not being reflected in a political process. So therefore, the court might want to step in. And the question is, where is gay marriage if you're evaluating it on this sort of political process breakdown scenario? And there are arguments on both sides of that. You also raise an important issue, which is, well, should the court be acting? I think descriptively, the court tends to, over time, align itself with public opinion. Someone once said the court reflects the climate of society, but not the weather of the day, right? You don't want attacking back and forth every time some political issue becomes a good fad, but at the same time, when you have these big issues, we're talking about racial equality, we're talking about sexual orientation equality, you probably do want the courts to be responsive. Should they be? Probably. Then how does it even work, right? You talked about term limits, you talked about maybe lifetime appointments might not be the best thing if you actually think the court should be responsive. Generally, they do tend to respond, oftentimes with a bit of a lag, but over time it does seem like that's a pretty accurate description, which is why I think all of us up here would say, you know, the big gay marriage decision is probably not going to come down in June, but it's going to happen. I mean, these changes are pretty durable. They're going to happen. The court will eventually respond. At some point when there's only a handful of states, perhaps, that do not recognize same-sex marriage, that would be a very historically traditional situation in which the court would then step in.
Hi. I had a question regarding the Windsor case. I'm a little bit skeptical of a broad, sweeping opinion from the court, just kind of, you know, in light of the Sebelius case. And the court, I think generally, in more recent terms, has been reluctant to, or maybe it's just the fact that they're all kind of split, to have these broad, sweeping decisions. So I kind of predict that they'll do it on a more narrow ground. They're decided on a more narrow ground. In case that does happen for the Windsor case, and they hypothetically say that Section 3 of DOMA is unconstitutional based on the 14th Amendment and equal protection, I mean, Professor Baker raised the hypothetical of, you know, what if, you know, you got married in Illinois and, you know, you were on a road trip and you got in a car accident in Alabama and the hospital wouldn't recognize the spouse as a parent. Let's say the other biological parent wasn't present. And, you know, that person maybe would have had standing in this future hypothetical to, you know, sue, arguing that Section 2 of DOMA is unconstitutional. In that case, I feel like Professor Baker brought up the problem, or the other case from Massachusetts, the First Circuit case,
yeah.
Gill, that the states actually argued that the DOMA violated the 10th Amendment. I feel like in this other hypothetical, the states would, it would be the opposite.
Right.
So the states would argue, no, you can't tell us that we have to. Do you know what I'm saying?
Yes.
So I'm just wondering, in the hypothetical situation that they strike down Section 3 of DOMA, but then, you know, Section 2 is still untouched, and then in this future hypothetical, if that happens, what would be the case? Could you bring up the 10th? Do you think that the 10th Amendment argument from Alabama would be stronger than the 14th Amendment argument?
The problem with any sort of challenge to Section 2, in my opinion, is that Section 2 did nothing but codify very well-established law, right? States have always chosen or not to respect marital determinations from other states subject to their own public policy. And so, though your example is particularly troubling, and I know of nothing in the history of these cases that suggests something like that, like someone's dying in the hospital and their partner can't come in, there are lots and lots of instances of different states saying, no, we're not going to treat you as married because you were 12 when you got married in another state and we don't recognize that. Or we're not going to treat you as married because you've only had a common law marriage and we don't recognize that form of marital union. So if there's something wrong with Section 2 of DOMA, it's that there was no purpose, right? It's just this blatant animus. There was no purpose to do it because all the states already do it, and Congress just wanted to say nah, 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 you know, to all the gay people. So I don't think that given the long history of not necessarily respecting marital judgments from sister states, I don't think it would be a big issue.
It's a few minutes after 4, so if there are no more questions, we can I invite you all to join us at the reception in the lobby. And please also visit the Asian American Law Students Association bake sale, because they very generously were willing to share the lobby with us. So there are no suites at our reception. Go to the bake sale.